I accept from what you say that you use that interchangeably with lead investigator. For you, it's the same insofar as the Mukwele matter is concerned. So I suggest we drop the title docket carrier and we stick with lead investigator, and we know that is you in the Mukwele matter.
Acknowledge, Counsel. I know it creates confusion, but yes, we will stick with lead investigator.
Unless Advocate Silo, he wanted to make a particular distinction which is relevant. I still don't understand why you would have mentioned the docket carrier if you are the lead investigator and it's irrelevant that you were also the docket carrier. What is the relevance of you mentioning that you are the docket carrier?
Perhaps before he answers, the
yes,
proposal I made
yes,
is based on the response he gave to the chair in trying to clarify whether there's a difference between lead investigator and docket carrier, because originally he had said he was just the docket carrier, having identified that there is a lead investigator. And in his engagement with the chair, I thought he got to a point where he said, for purposes at least of Mukwele, docket carrier and lead investigator, both of whom are Mr. Colonel Padayachee, is the same thing. So I was just requesting that if my understanding is correct, that docket carrier and lead investigator is how we should understand it, then we drop any reference going forward, yes, to docket carrier, and we just speak about a lead investigator. So that's what I was trying to confirm with him. But Commissioner Khumalo, if you remain unclarified on some issue regarding these terms, perhaps the witness can clarify for you.
Clarified. We will drop that and we will stick with lead investigator. There's no other. Sometimes when you are working in a team, you use your different terms, but lead investigator, that is it. In order to avoid confusion with docket carrier, we'll stick with the lead investigator, the one that's carrying the docket.
I must say, the way it came across, it sounded as if you were trying to avoid the responsibility about certain things, and you were trying to say, oh, that's the responsibility of the lead investigator. I'm just the docket carrier. You know, like, no, I'm the messenger, don't shoot the messenger type of situation.
I hear you, Commissioner, the inference that can be drawn for it. I think I must get the message across clear, that we drop the word docket carrier, lead investigator, but in the team, I report to a chief criminal investigator. I think that makes it much more understandable from the English point of view, if I can go there. Thank you, sir.
Thanks.
I know you would like this to be resolved neatly in the way that you've done, but just to clarify for myself, when the team was first constituted, and this is partly, my question is partly about the structure, but also this particular case, when the team was originally constituted, would you have had a docket carrier and a lead investigator and a chief, what is it called? Chief investigating, the position held by Perumal. Would you have had a docket carrier and a lead investigator in this particular case?
No, Chair. I think that creates, that's where I'm creating the confusion. That's why I dropped the docket carrier. But I think it comes more when you look at that team.
Yes.
That team that is there, there's a number of different investigations.
Yes. No, my question is simply this. On the Mukwele matter,
yes,
from the outset, you were the docket carrier / lead investigator.
Correct. Section 27 deals with the reporting of matters to the investigating director. If any person has reasonable grounds to suspect that a specific offence has been or is being committed, or that an attempt has been made or is being made to commit such offence, he or she may report the matter in question to the head of an investigative director by means of an affidavit or a firm declaration specifying the nature of suspicion, the grounds on which suspicion is based, all other relevant information known to the declarant. So that refers to a complaint that is referred in terms of Section 27. That's the starting point. Section 28, inquiries by the investigating director. In terms of Section 28(1)(a), If the investigating director has reason to believe, to suspect that a specific offence has been or is being committed, or that an attempt has been made or is being made to commit such offence, he or she may conduct an investigation on the matter in question, whether or not it has been reported to him or her in terms of Section 27. So, when a complaint comes in, it comes in under an affidavit in terms of Section 27 from a complainant. The 27 comes to the head of office. The head of office is the investigating director. It goes to the case intake committee. They will look at this referral and will decide whether it falls within the mandate of IDAC. It's tested within the IDAC criteria. From there, looking at it, there will be two things that would take place. If there is sufficient information on that referral, a full-blown investigation can be conducted in terms of Section 28(1). If there's still further investigation to be done, then a Section 28(13) is approved for a preliminary investigation. So we start with the 27 coming in with a preliminary investigation on Section 28(13). A Section 28(13) is approved for a preliminary investigation by the investigating director, the head of office. During that authorization, the preliminary investigation is authorized. It lists out the offences that's going to be investigated. It lists out a designated team of prosecutors and investigators. So there's a list of all these people that are put in there. That is there. That designation is their authority to proceed and conduct the preliminary investigation. So once that preliminary investigation is authorized, the preliminary investigation starts. So after a period of time, investigation, interviews, subpoenas, or whatever is done to confirm that there is a preliminary case here, it is taken back to the investigating director. The matter is considered by management, and then a full-blown investigation, Section 28(1), is approved. So within the Section 28(1) investigation, if there's additional expertise, additional investigators, or other role players that need to form part of this investigation that has come up now from the preliminary investigation, these additional people are added on to the designation and authorization of this full-blown investigation. Thereafter, the team is assembled, the prosecutors, the investigators, and the investigation commences, directed and led by the prosecutors. The investigators in that team, or I should say, to list that team, there's a Deputy Director of Public Prosecutions. There are senior advocates, junior advocates, depending on availability, one or more. And then there's a Chief Criminal Investigator who is responsible for the senior criminal investigators and the criminal investigators. They report directly to the Chief Criminal Investigator in that structure. So once that is put together, the Chief Criminal Investigator assembles his investigators. He's got more or less the puzzle on hand of the investigation, and then he tasks the investigators accordingly. So in that specific task, it will be like, for example, myself that is appointed now to conduct this investigation with the assistance of the other investigators. So you go out, you interview, obtain witness statements, other related evidence, and that is brought back. The team would, together with the prosecutors, look at this evidence, they analyze this evidence, the prosecutors look at it, and if they see that there is sufficient evidence based on facts, then they will start with a charge sheet on who they're going to charge, and what charges they're going to put. So a memo is put together with a charge sheet. That charge sheet and the memo is presented to the deputy director of that team. He looks at it to see that, okay, the facts, the evidence is supported by facts, that there is evidence, and the docket is now ready. That is then now taken to management. It's presented before management. Management will decide, yes, they agree that it should go on, and then the next step is the matter is ready to be enrolled. So the enrollment procedure is thus: you look at the prosecutors look at the charge sheets, they get the charge sheets ready. They also do a consultation note, which is a note to the Director of Public Prosecutions in the region where the matter is going to be prosecuted. So that consultation note is sent to the Director of Public Prosecutions. He or she agrees that yes, you can proceed to prosecute the matter in that particular region. Once that is done, the charge sheet is prepared. Then the enrollment processes start, where an application is made for J50s, that is your arrest warrants, or your J175s, if that is necessary, depending on the circumstances. Then
you said J175?
it's a summons. It's a summons to appear. So once that is done, your warrants are prepared, your affidavit is prepared, your warrants are prepared, and then you are ready for court. So then you will plan your operation and to execute your summons or your J50s. You will also have, depending, during that time, we will pick up, but this is Schedule 5, Schedule 6. Then you'll start preparing bail affidavits, because with regards to Schedule 5, there are serious offences, and it will be on the accused, onus on the accused for him to be released on bail. So then you make arrangements with the court, you have the matter enrolled, and then the processes flow from there.
Thank you.